Robert, let's start with the biggest one of the week, I guess, is the Chauvin update, the Chauvin trial, getting to sentencing now. And you correct me if I'm wrong. I think I understand everything there. Prosecution, defense have submitted their memoranda for sentencing. As far as I understand, the sentencing guidelines in Minnesota for this type of crime tend to be somewhere in the order of 15 years. Defense is asking for probation with time served. Prosecution is asking for 30 years. I think the most material thing in all of this is the aggravating factors. Do we call it a decision, opinion that the judge issued, I don't know, a month ago now, where he concluded to aggravating factors that, the aggravating factors presumably as relates to sentencing, right? They're going to have an impact on sentencing. Those aggravating factors were Chauvin committed the crime in the presence of children. He committed the crime with a particular, I forget what the word was, but evil intent. There were other conclusions, other findings of fact and law that the judge came to that give an indication as to where he's going. Explain to those who may not appreciate what that opinion, what that order was that the judge issued previously, and what impact, by and large, or by all accounts, it's going to have on sentencing.
Well, I mean, basically, typically you would get, without aggravating factors, 10 to 12 years, which in Minnesota would translate often into about 6 years of actual custodial time. And that would be probably a medium security facility. So this sentencing is not only the length of time you serve, the probabilities of you getting out early, and it impacts also where you serve your time. So that's it often matters in ways people don't think about right out of the gate. And so what the prosecution is seeking is 30 years, which would be a maximum security facility in which he would probably do more than 15 to 20 actual time just on these charges, because he still faces tax charges. He still faces additional federal civil rights charges, which would add time to that. So that gives some sense of what he's facing. What the defense is asking is probation, on the grounds that the incarceration system doesn't work. It will be interesting whether any of the opponents of incarceration, a very popular movement on sort of the legal left, what do they say about Chauvin? My guess is they'll go into the night and hide, which will embarrass their ability to be politically honest. They're saying, look, don't focus on how we want to let rapists free and kitty and child, abusers free. We just don't think the incarceration system works for anybody. Well, if that's true, then that would be true for Chauvin. My guess is they won't say anything. But that's the core of the claim and by the defense. And I think it comes down to the judge. He has very broad discretion. Almost all judges do in this area. Their factual findings can be subject to review of a certain type, but I don't see a court of appeals overturning him on this aspect. In all likelihood, my guess before all of this at the time of trial was that it would be a likely 18-year sentence. I'm going to stick with that because I thought the judge was hostile to Chauvin, but wanted the trial to be seen as a fair trial, and actually did work mostly hard to create that outcome. I mean, there's some rulings he made that I think undermine that, but I still think that's his driving motivation. In other words, he wants Chauvin harshly punished, but doesn't want to be seen as being vindictive. And so I think he'll stick pretty close to where the guidelines go, and that would be about an 18-year sentence. And so I think that's where he'll end up.
I don't think we actually ever went over is it an opinion, a memoranda, the conclusions of fact for aggravating factors, however we phrase, whatever it's called. I don't think we ever actually talked about it, but I was inclined to believe, and I still do, the judge looked like he was going out of his way to be impartial, to give the fairest trial possible under the circumstances, notwithstanding not changing the venue, notwithstanding a number of decisions, during the course that you could say they're bad decisions, and then you could look for motivation, whatever. But in this aggravating factors memorandum, there were two conclusions he came to, which I had questions about as a matter of law, and I watched Nick Riccado's breakdown, and he raised the same issues. The two of the aggravating factors in particular: one, committing the crime in the presence of children. As a matter of fact, I don't recall how old the children were in the circumstances of this video. I didn't think they were children I think they were teenagers. I don't know about that as a matter of fact, but that factor, how is that typically applied in law? Because it seems to me committing the crime in the presence of children, the children being not targeted by the crime, but rather being witnesses. It has to be something of an intentional, or at the very least, center item, and not something totally incidental where any crime committed on the street can be a crime committed in front of children, where this aggravating factor can come into play. How does that factor typically apply in criminal law?
It varies. I mean, these are specific to the state of Minnesota. So each state has its own sentencing procedures. The federal system has its own separate sentencing procedures. These were the procedures that he could have had the jury determine, instead had the judge determine. And ultimately, there was no difference in what the jury likely would have determined and what the judge did. I think it did some of the way he described some facts in that sentencing memorandum or sentencing order on aggravating factors showed that what I suspected was true, which was that he was not if this been a bench trial, he would have come to the same verdict as the jury. I think he was very hostile to Chauvin. He was also, however, someone who valued the perception of fairness. And I think in his mind, he thought he was doing a fair trial too. I have no doubt about that. I mean, someone that was by a bad judge would have tried to rig the system. I don't think he did that. I think he may have created that effect by some of his decisions, but I don't think those were intended by other course of conduct that he engaged in. But I think that he wanted to make it. I think he always thought that Chauvin should hang, but he wanted people to have confidence in the outcome that produced it. Ultimately, he failed because of how the jury determined things. But I don't think he's going to correct that on his own. And I think he'll come in with a sentence that will look good from a PR perspective, but not look vindictive. If he comes in with something 25 years or more, it's going to make a lot of his decisions look worse. Because then people are like, well, okay, you came in with an extraordinarily harsh sentence that's harsher than almost all murderers get in Minnesota. Then people are going to look at that venue decision and some of those jury decisions a little differently. If he's smart, he'll come in 15 to 18-year range. But we'll see. I think he's smart and he will, but 25% chance he goes high.
All right, I'm going to bring in Beavis Wallace's question because this is going to bridge into another question I had on that aggravating factor finding. Does Barnes believe that the prosecution proved murder beyond a reasonable doubt? I mean, we don't need to go over it again because we've gone over it at length in previous streams, but the felony murder...
I didn't think none of them. I didn't think they convicted him of anything beyond a reasonable doubt.
But I mean, just so everybody appreciates, and there was a beef going back and forth with it's not so much a beef, but Nate.
I thought
there
were legal defects too with the proceedings, and other people have. A lot of people like Nate doesn't really disagree that the law is crazy. He just thinks it's legitimately interpreted the way the judge did. I think this Minnesota Supreme Court should set it aside. But whether they have political wisdom to do that, that's the long shot in this case. It's the lead, in my view. The Chauvin trial is not about Chauvin. He'll go to prison on something between all the things he's facing. I think he may be guilty of a civil rights violation because you don't necessarily have to prove causation to prove that. But you don't even have. It could have even been after he was dead that he did things that could be a civil rights violation under certain circumstances. So the legally or medically dead. But putting that aside, to me the case was never really about Chauvin. The case was really about our legal system and could it produce a trial that was fair both by perception and substance. I think it failed both of those tests. But the sentencing will be the last straw to show how much is this judge really anti-Chauvin versus how much does he value the perception that he's not being vindictive and this was not a vindictive system. That's what the sentence will reflect, in my view.
And just so everybody appreciates the nuance out there, felony murder, he found guilty of felony murder, which means that he had to be found guilty of the underlying felony, which led to a death, hence no actual intent to cause murder, but rather to cause the felony that resulted in the murder. The distinction, or the thing that everyone, most people have taken issue with, is that in this case, the underlying felonious act leading to murder was the assault itself. And on the one hand, you have a finding of felony murder, and on the other hand, you also simultaneously have a finding of manslaughter, which typically implies a lack of intent. And this comes into the second question that I had about that aggravating factors memoranda, where the judge came to the conclusion that he acted with particular cruelty, I think was the term he used. And the question is, people are asking it, and it's a legitimate question. If he's found guilty of manslaughter, which means negligently causing someone's death, how can you then come to the conclusion of particular cruelty in the negligence that led to the death? I mean, it's almost like particular cruelty in the reckless. I mean, how do you reconcile that? Because the particular cruelty is specific intent, and manslaughter implies a lack of intent, but rather a reckless disregard.
It shows where the judge's mind was, in my view, that the judge was extremely anti-Chauvin. That like some people had thought a bench trial would be better than a jury trial. That's almost never true. That they've looked at cases and studied, and unless somebody that's a part of the politically protected class is on trial, bench trials tend to be worse than jury trials on average. Depending on where your viewpoint is, but on average. But usually they don't differentiate much at all. Whatever biases a jury has, a single judge is even more likely to have, frankly. So he put any illusion of him being a fair decision maker to rest with the decisions he made in that memorandum.
And now the question is, they've submitted the sentencing memorandum. Are there arguments on this? Are there pleadings, or is it strictly written? And second question, what happens to the pending motion for a new trial?
That's all pending. So presumably he'll make all of that at the same time. I mean, it's unusual to have a sentencing judgment. You're supposed to do that before the judgment's issued. So you make a ruling. I assume he'll have oral argument on all of it, and presumably at least before he issues the final judgment, because you have the sentencing and then the judgment comes after that. He'll clearly resolve those other motions, I would presume. Okay. I think he's going to turn them all down.
No, I mean, I imagine that looks to where it's going. I mean, given his findings of fact, it would be very peculiar at this point to actually just undo everything and then make him go do it again. He's come to conclusions of fact that he stated now. To say that it was based on an improperly conducted trial would call into question the very conclusions he came to that he put to paper. Okay, shall we move on to the next big one, which I know people are talking about, the Second Amendment decision coming out of California?